Hi everyone, I'm very excited today because we're here with Maître Patricia Fourcan, and I'm very excited to be discussing what we're discussing. Maître Fourcan comes from the law firm which she's one of the founders. It's called Fourcan, Tremblay, Kissel and Plante. And I look forward to discussing this wide array of topics with you, along with Samara Wigdor and Etienne Mellor.
And I think we should absolutely start with the latest changes in the law that for us, anyways, has a somewhat of an impact, which is, if I'm not mistaken, and you correct me, Law 56.
Well, it's called the parental union regime.
Okay.
So it's an act that reforms the family law and that provides for families who have children who are born on or after June 30th, 2025 for specific assets that can be partitioned, and therefore that protects the family, the children in particular.
So for us as real estate brokers, agents, how would that be something that would impact our clients? Or is it something that, in your opinion, we should be aware of to maybe discuss with our future buyers or future clientele?
Oh, absolutely. I think it's extremely fitting for you and your clients to be aware of this law because it changes the game completely. So before that, if you had a spouse, a de facto spouse, who was sole owner of a family residence, and the separation arrived, he would have the right to have 100% of the proceeds of the sale of the family residence, or to continue being sole owner of the family residence if that was the case. Whereas now, with this new law, if they have children, they are born on or after June 30th, the other spouse, even though that person is on the deed of purchase, is entitled to the partition of the net value of that family residence. So it changes the game completely.
It's a big change, and I think Alex, you were talking about how big of an impact it has or has had when you discussed it with some of your clients.
Yeah, so also, I was very wary of the different laws in Quebec versus the rest of Canada because I grew up in a family that was full of lawyers. So I was very interested in this. And also, I had clients that were interested in this because if they're thinking of having children or if they already have children. So I understand that it does not apply to someone without children. Is that correct?
Absolutely. That's why it's called union parentale and not, it doesn't apply to de facto spouses. It applies for people who have had children and the children were born on or after June 30th of this year. However, parents who have kids who were born prior can ask that the law apply to them. To do that, they need to go in front of a notary or sign an agreement in front of two witnesses.
Okay, and I know we're getting really deep into this law, but have you seen or have you had a lot of requests from people requesting that they opt into this law, or it's been low demand?
I think we only have had one so far. It's early days. We're only in July.
It's
been, but that's why I think this type of interviews are so relevant, because hopefully people will be more aware of those rights and of that right to have that law applied to them, and hopefully people will be conscientious of how to do it. So you can't just do it in front with your spouse on a corner kitchen table.
No.
You need to do it in front of two witnesses or in front of a notary.
Wow.
And the purpose of this law, obviously, I know you weren't necessarily involved in it, but why did it come about? What was the issues or the main thing that we were trying to solve with this law?
So, contrary to most other Canadian provinces, in Quebec, if you're a de facto spouse and you had children or you had a long-term relationship, you're not entitled to anything, no spousal support, no family patrimony, no matrimonial regime. The only option you had if you were really in a horrible situation after having invested in your family and or in your husband's business was to ask for an unjust enrichment. which is a complicated, costly, way to try to get some compensation. So basically, there's some lawyers who contested the fact that the Quebec laws did not provide for rights for de facto spouse the same way they do for married spouses. And that case that was commonly known as Eric versus Lola went to the Court of Appeal. And the Court of Appeal had come to the conclusion that it was anti-constitutional not to provide rights for de facto spouse, but that decision went to the Supreme Court, and the Supreme Court said that it's not anti-constitutional and that it's the role of the Quebec legislation to enact laws if they wish to protect de facto spouses. So following that decision, the government started a reflection, an attempt at finding a law that would provide rights to parents while still respecting freedom of contract.
And I think, and now I'm going to verify this, but I think that in Quebec, it's one of the provinces where there's a high number of couples with children that are not married, and that possibly could be also a reason. Are you saying that all the other provinces in Canada have something similar to this?
Well, they have something more generous. Generally, like let's say in Ontario, I'll talk about Ontario that I know better. The de facto spouse is called common law spouses, and they have rights that are very similar, if not identical, to those of married couples. Where even now with this new law, the advantages are not at all as generous and as all-encompassing as it is for married spouses. Let's make a few. For example, RSPs, pension funds, are not partitionable for under the parental union regime, but it is for married couples. There is no spousal support for under the parental union regime, but there is for married couples. And there's not the matrimonial regime of ACWEST, which is let's say the automatic regime that applies if you marry. Basically, that says that all assets acquired after marriage, if they were not acquired through donation or inheritance, are partitioned 50-50. So all of that does not apply to the parental union. But what is very relevant for all of you is that the house, however, is partitionable.
Yes, and for most, that's their biggest asset, biggest
absolutely
investment. So.
Absolutely.
Great. Well, maybe a question
fascinating.
that ties into is one that we get often is what's considered family patrimony in Quebec? Like what's the definition of
Perfect. So family patrimony applies to married couples. Only. And it includes certain assets that are generally what most people have. Most people assets are limited to that. So, and it's RSPs, pension funds, family residences. So that includes the primary residence, but also the secondary residence, be it a country house or a condo in Florida.
May I interrupt? Is that why? So the acquisition of these assets was done while the marriage existed, not prior to. Is that correct, or am I wrong?
Well, let's say you have an asset that you purchase before marriage and you're 100% owner of that property. If that house is paid in full and there is no mortgage, that house is not part of the family patrimony. But if there is a mortgage, let's say the house is mortgage as to 50% of its gross value, well, the percentage that is mortgage, so that 50% which is mortgage that was not paid off prior to marriage, is part of the family patrimony as well as it is increase in value.
Okay, because they're paying it off, so it's assumed that it's the family paying it off.
Exactly. Right. So what you do is you include the house, even if it's purchased prior to marriage, and you exclude the net value at the time of marriage.
And did I misunderstand? It has to be more than 50%. The
no,
loan?
No, I was just giving you an example. Okay, yeah. So pro rota or percentage-wise.
Okay, so any debt, that be 5%, 1%, it doesn't matter. Yes. That is going to be considered into the family patrimony.
I have a question related to that. It involves inheritance. So what happens if, let's say, someone gets an inheritance and they put that into the house. Do they still have a right to that? What if they put the money into the house, but they're not on the deed? What happens with that?
Very interesting. So first of all, let's say that you are on the deed and you have an inheritance. You have to be able to prove that money that you invested either by renovation or paying down the mortgage or as the initial mise de fonds, that this amount came from inheritance. So you have to have the paper trail, because if you cannot prove that it came from inheritance or donation, you will not be entitled to this deduction,
Okay.
to
Oh,
exclude
okay.
it from partition. And so not only would that amount be excluded from partition if you have the proof, but also its increase in value would
Really?
be. So you have to make sure that you have the paper trail, and ideally, if it's at the time of purchase that you're using it as a down payment, ideally you add in the purchase agreement that that amount was what was provided from a donation or inheritance, and that if ever the partition of the house or the house is sold, that amount as well as increase in value has to be repaid to the person who made that contribution prior to partition the net value. So that is very important to have the paper trail and hopefully to have like the proof thereof, and ideally the acquiescence or recognition from the other, admission from the other party and other spouse that that money came from donation or inheritance.
Does it change anything if they own the house already, and let's say they put in money from an inheritance into paying down the mortgage, or they've owned the house for a long time already, or into renovations? How does that change? Doesn't change.
So that applies also. But again, let's say if it's renovation, it's not the cost of the renovation that is that you're entitled to as a deduction. It's the value, added value to the family residence of those renovations. As we all know, some people make major renovations just because they want the house to be more to their liking, but it does not necessarily add a similar
Value.
Market
value.
value.
So in those circumstances, we have to have an expert evaluator come and say, look, without those renovations, the house would have been worth X amount, but with this renovation, it's worth 10% more or 5% more or whatnot.
And that's what goes into.
Exactly. And again, it's a question, as always, it's always a question of proof. So that's more difficult when it's on a deal, you're buying, a can of paint to try to keep the paper trail and the proof. So what I recommend always to people who have money that they receive a donation or inheritance, to have a specific bank account for those amounts. So there's no commingling. So you know that whatever amount came out of that account, and you keep your checks and you see like all of those amounts came from that one account, and that one account only has money that came from donation.
It makes me think, what would be, if any, the percentage of people that actually come to see you before getting married and go over these types of questions? Is that even an amount at all?
Yeah,
or
of
do
course.
people they just fall in love and they don't think about that? They think about it too late, maybe.
Well, often I find it's the parents. So I would
Because
say
maybe they had the experience of
or they
the
have
bad experience.
no, or they have family businesses, and they want to make sure that they're able to transmit the family business, to make donations, to make inheritance
I'm going to
without
be taking some notes now.
exactly without having putting their child in a complicated legal situation with their spouses. So oftentimes it's either a second marriage or the parents of the of their child is about to get married, who will contact us, and we will sit down with their child and explain to them their rights and obligation and the laws and how to best do asset protection regarding the family assets, and we discuss if it's appropriate to have a matrimonial contract, and
Well, I had that as a question. This is
marriage
something
contract,
that we meet the clients. Samara and Alex will tell you, and we have a contract. It's for us interpreting the contract. It's not always a black and white simple thing to do. The marriage contracts is that something that changes a lot in regards to what we just discussed, the different laws, or not really? Is a contract a way to just make up our own rules as a couple, or not really? It's just we still have to follow certain the basic rules that apply to.
So a marriage contract can protect many assets, but it does not, have an impact on those assets which are part of the family patrimony. Meaning you
Okay.
can't contract out of family patrimony, which means that family residences, RSPs, pension fund, cars, furniture, all of those assets are part of the family patrimony, which is of public order. So you can't contract out of that, and you can't contract out of spousal support or child support.
Yes, that I found out the hard way. Give you a quick story. So no, but this is important because no one knows this, and I've spoken to a lot of people that got divorced, and we're all in the same boat. We make our own agreement. Let's say we're separating. We think that okay, you're going to get this, we're going to get that, and it's hard enough already to have that conversation. But we settle on let's do this. So we had a great plan. And instead of going and seeing a lawyer, we went to, now I forget, it's a long time ago, but as a mediator or someone that's going to just validate or officialize. I'm not sure. And this person tells us at that time, we show our plan, we're all proud. We're thinking, we're getting along, this is great. They show the plan and she says, no, you can't do that. And she starts explaining the why, different equations when it comes to revenues, length of time of marriage, kids, and so on and so forth. And so everything we had sort of thought settled, it just got thrown out the window. And so my lesson there, but I want you to correct me or recommend or suggest, is maybe you need a lawyer. I don't think you can do this on your own. I guess it depends on the complexity of or the length of marriage. What would you say?
You mean when you're separated, if
Yes.
you need a lawyer? Absolutely. I mean, for most people who are not, major businessmen, even for small business people, the contract that they will sign or the agreement they will sign that will have the most financial impact on their children, themselves, and their future is their separation agreement. So, businessmen would not think of, that's not a lawyer, a business law lawyer himself would not think of doing a transaction for 2-3 million without even consulting a lawyer, reviewing the draft agreement. So that's the same thing for separation or divorce, because you might think, especially today with ChatGPT, people think they know the answer, but there's always, an exception. There's always a detail that, some people can't fully understand or appreciate. Even lawyers who are not specialized in family law, they can forget something or not take
So that was
something
my
into
biggest regret.
consideration.
And we even again, without having the laws, I agreed to something that was suggested by this mediator. I forget the title exactly.
Yeah, mediator.
But there was no terms.
Right.
So when I actually later on consulted with a lawyer, she told me, she says, you don't even have a term on your. So I had to, and all that to say, it ended up costing me way more in just lawyer fees, and because I thought I was saving originally, but it ended up costing me a lot more, and it lasted a lot longer because of it. So. Well, I don't think there's a place. Sorry to say, I don't think there's a place for saving when it comes to
Protecting
separation,
yourself.
divorcing.
Yeah, absolutely. Same thing for a marriage contract. It might cost, $4,000 or $5,000, but it might save you $1 million later on. So it's not a bad investment. Again, for sure, you want a lawyer that's collaborative, a lawyer who will not encourage unnecessary litigation. That's a lot of the reason why some parents or some couples don't want to see lawyers, because they're scared that one of them is going to be in the grips of a person who's going to encourage confrontation.
You have to find the right one. Again, I'm talking from experience. I met with a lot of different friends refer, business colleagues refer, and then you meet them and then you see their philosophy. I 100% agree with what you're saying. Some are very pro certain ways of going about it, and so it doesn't always fit the personality. It's good to interview or
absolutely.
have a
I think that you really have to have a lawyer who represents a bit your mentality, your values. I always say that you have the clients that you deserve.
Yeah.
The person is always complaining about their clients. I'm like, well,
But you
what does it
attract.
say about you?
Yeah, 100%.
That's a good one.
I like that.
That's
Yeah.
a really good one.
Yeah.
So hopefully
Exactly.
that's the idea. You attract the right
Absolutely. And
client.
like a lot of my clients are friends now, and they're people that I respect and love and appreciate because that's what I attract.
Etienne mentioned one of his regrets that he had. So, on the note of regrets, what have you seen when it comes to the single family home be the biggest regret of your clients? Of, I should have protected myself more this way, or
Yes, I think the biggest regret is people not understanding what is partitionable, what is not, the exclusion, and not having the paper trail to prove, for example, that the house was purchased through inheritance or donation. I think that's one of the people's like big regrets, or leaving the house
Well,
too fast.
I have that as a
Yeah.
question that I get from brokers will say, oh, the one of the spouses doesn't want to leave.
don't leave the house.
Yeah, well, let's clarify that because
Why?
I never understood that one.
Because it's so mentally taxing, already you're having a
Yeah.
separation and it's tense in the house and you have to stay there and they're being told do not leave the house.
Yeah.
Why?
There's two reasons. So first of all, let's say you leave the house without having an agreement on custody, and you don't even have a proper new house for the environment for the children, and so they stay with the other parent, and there's a status quo
Oh.
that of that parent having the children
Abandoned
the
well, not abandoned. That's not the
yeah,
right word, but
no, that the status quo is as that parent has the children most of the time and
Right.
has usage of the house. It has had usage of the house and has had the children for the majority of time for 2 months, 3 months. What happens? You go to court. The thing that the courts do on an interim measure, which is safeguard order, which is the emergency measures, they maintain the status quo, which means that if the person who stayed in the house has the children the majority of the time, 60% or more, that person will have, a majority parental time. If that person has been in the house for 2 or 3 months after the separation, that person will continue having usage of the family residence.
Wow.
So there's no incentive to settle quickly because with the judicial system as it is, it can take 3 years to have a court date, which means during those 3 years, you might be stuck with not having a 50-50 custody and not having usage of your house and not having the proceeds of the sale of your house to be able to buy a new house.
Wow.
So,
sorry, Alex, but so
Go
for
ahead, go
no,
ahead.
but when we talk about buying out the spouse, then because that's another one I get a lot. I don't know about
Yeah.
you guys, but
Yeah.
well, no, we're gonna buy the other person. Can you help us as a realtor, as a real estate broker?
And can can one person force a sale? Does that work as well?
yeah, so if let's say they can't agree on the price or who's going to be keeping the house, what the courts will do is they will force the sale of the house. But it cannot necessarily, generally, it is not done in the beginning or the middle of the litigation. It's done at the end of
At the
litigation.
end of the litigation.
Except if you can prove that there's financial hardship or that there's a very serious reason, an urgent reason why the house should be sold.
So as realtors, how do we know and when should we participate? Like what would be maybe a cue that, okay, we can now participate in representing one or the other party? Because that's one too that I think is very misunderstood.
On top of that, I also find frequently that both parties feel that they need their own real estate agent a
Yeah,
lot of the
that
time.
happens often. Yeah.
Yes.
So I wonder what your opinion is on that.
Well, I think that can cause conflict. Like the realtors might have different ideas as to the right price to put the sale and what offer to accept or not. But sometimes that's the only way to go forward. So That's what we do. But you can't put a house for sale if it's without both of the owners giving you mandate.
And a judgment or what would that document be? Is it called a judgment or something?
Yeah, a judgment or order of the
saying
court.
you can sell the house. Right?
Absolutely.
Because again, I'm going by memory of my experience. We couldn't touch the house until
Exactly.
something was pronounced and we had an official document. So as realtors, as agents, we need to ask for this document. If Alex is going to a client's house and they're saying, yeah, we're separating, well, we need proof that we can actually put the house for sale.
No, it could be consent of the other spouse.
As long as we have
As
consent.
long as it's amicable, you mean? It's
Yeah.
okay.
Well,
Yeah,
if the
okay.
other party signs is what
Yes,
you're
exactly.
Yeah,
saying.
you
Yeah.
have their intention on the paper.
So
Exactly.
I mean, it goes back to what we were discussing before. My question is, let's say we have a client coming who says, I'm thinking of leaving. We obviously can't advise them. We're not lawyers, but what can we inform them of? What can we inform them in our role as a real estate agent, as a real estate broker in Quebec? What can we tell them?
You give
They
the
s-
Maître Fourcant's phone number.
Well, I think you have to be very careful. Like
Okay.
even legal information, I don't think should be
Okay.
your responsibility to
Okay.
do that. But I think yes, telling them to see a lawyer is a good idea, and tell them because there are things that you can do, to protect the property, to protect your house, to make sure that the house is not sold without you knowing it. Let's say if the other spouse is 100% owner of the house. So I think I would keep it very, vague.
Okay.
Because of course there's a lot of things we can do to protect a client who's thinking of leaving. First, regarding the house in particular, if that spouse is not co-owner of the family residence, we suggest that they make a declaration of family residence. That's only for the primary family residence. You can't do that for your secondary residence, like the country house or the condo in Florida or whatnot. So, but for the main family residence, you can put a declaration of family residence, which indicates to all third parties that that person who's the sole owner cannot sell this property without my consent because it is part of the family patrimony and we're married.
Is there something that you would say to real estate brokers or agents? Do you get to hear or have situations where you feel like, okay, the agents or the brokers don't understand, or that's not even something that the clients will discuss with you?
Well, sometimes we do discuss with real estate agents, but I have to say that I find that most real estate agents are very careful. They try to obtain information before doing something that's inappropriate. I have to say that I've had only great experiences working, collaborating with real estate agents. So I find that without them giving legal information, I find it's very important, if possible, to have a real estate agent when you're selling a house because they're there also to protect your rights in that process. And I think they're generally, from my experience, they've been very helpful in the process.
I'm very glad we have a good name in the legal world.
Yeah, well, because I find that oftentimes, especially if you only have one real estate agent, that person really is the expert in in all issues regarding that family residence.
Yes.
They can tell us, is this the right price? Should we lower this price? Give us realistic expectation. And
I'm happy you're talking about that because this is something that I get often where the couple is separating, our broker calls and says, they can't agree. We have a
price,
great
yeah.
offer, but one of the spouses is refusing to accept. So
no,
I
yeah.
always say, well, speak to one of the spouse, whoever it is that's arguing, speak with their lawyers because we, in our role, cannot get involved in that. But is that the right recommendation or? Because one spouse cannot block the other, I'm sure. Well, maybe not. I don't know. Can he? Can she or he block
Well,
a sale?
usually,
yes,
yeah.
if they don't both agree on the price, then sale cannot go forward because you need both signatures, except if you go to the court, which is what we do. If a person is being unreasonable, refusing to
Intentionally
follow,
blocking.
Okay.
yeah,
Yes.
refusing to, follow the recommendation of the agent, then we can go to court on an interim basis and safeguard order and ask that the court order the sale of the house. So generally, what we will do is we'll ask the real estate agent if they can go to, let's say they've had an offer to the person making the offer saying, could we have an extension, like a 4-day or 5-day extension? So we have, but generally by that time, the other person
Yeah, I
has,
was gonna say they've lost interest usually. I mean, when you
Yeah,
get
we
an
lose
offer,
the
you have
buyer.
to move.
well, then
Yeah.
what we do then was, so if that person has lost interest, but well, then we'll still go to court and make sure that, for example, we can ask that the court order for any other offer that is of X amount or more, that
Yeah. No, I'm just thinking efficiently. I'm thinking if I had to do this again, could I go to you and say, okay, I want to. No, but step one. My wife is over there like, no. It's just I'm trying to think. How could we recommend? If I had to do this again, could I say, okay, well, we're going to settle on the price now, at step one of this agreement or separation agreement, that the value of the house, if it reaches $1 million, whatever the amount is, you have to
Yes.
so that we don't get into this scenario where there's these
Absolutely.
additional delays, additional fees, because
Fees, yeah.
that's a lot
So
of money.
oftentimes when it's possible, we think that might be a problem. We mention in the agreement either of the divorce agreement or an interim agreement until we have the final agreement. We say, well, the both parties agreed to use X real estate agent. The parties agreed to put the house for sale at the amount of, let's say, $1 million. And then the parties agree that they will accept any offer that is 900,000 or more. And the parties agree to keep this confidential, of course.
Right. Okay, so
And
there you go. That solves it.
yeah, we
Efficiency.
try.
It's very interesting, and thank you again for being here with us today.
Yes.
Another one of our questions, well, my questions was that what if someone tells you they're getting a divorce and they have children and they want to keep the house, but they don't have the funds to keep the house? Does someone in that situation have options, or is it just you can't afford it, it's done, and that's it?
Well, that person has to know that possibly she's entitled to child support, or he or she's entitled to child support, possibly spousal support, lump sum payment, possibly sums for partition of RSPs, possibly funds relating to the partition of acquests. So you really always have to tell them, well, it's not because you don't have funds yourself that you're necessarily unable to purchase this house. You have to go see a lawyer and see what your rights are.
I know that the banks actually take into consideration that income when they're doing a mortgage approval. So
Yes, so you have to have a signed agreement
Yeah.
that provides for child support and or spousal support with a clear amount and with indexation. So this is considered almost at the same level, of any employment income. Actually, it's
Yeah.
probably more because you have more chance of, especially if it's a fixed term that cannot be modified, diminished or augmented, and that's a guaranteed income, which we don't even have in our own,
Yeah.
Yeah,
employment.
no.
So once you have that, then you produce, this agreement or a judgment to the banks, and that is helpful to get a loan or mortgage.
So I know you're busy and you take new clients. Obviously, well, I shouldn't say that. Is there room for more? Is there? No, but I know how busy you are.
Well, yes, but we opened our firm a little less than 3 years ago. We were 5, 4 lawyers and 1 secretary assistant. And today we're 10 lawyers and
Wow.
with
Congrats.
thank
Yeah,
you,
congratulations.
paralegals and an articling student. So we're always growing to meet the demand. So yeah, for sure.
Thank you so much for doing this, by the way. I really, really appreciate it. This is something that we deal with divorce. I don't know what the ratio is, but it's a high amount as realtors.
Yeah.
And these types of questions are amazing that you're taking the time to answer them. So really, thank you. Anything that you would like to say to realtors more specifically?
Well, I think that it would be good for people to know that you have to be respectful of people's emotions and the timing. Oftentimes, there's one spouse who wants to put the house for sale immediately, but you have to say, understand it's traumatic for the spouse often who has, might have less means at the end of the marriage, who thinks she or he might not be able to have such a comfortable house. It can be traumatic for the children to lose their home at the same time as they're losing their families. So to be, respectful of, everybody's process doesn't mean that we have to wait 4 years for the house to be put on sale, because that can, damage the family's financial health also. That's not what we want. But sometimes, to wait a year, it permits the spouse that might be more traumatized, let's say, by the divorce or separation, to heal, and for the children not to make the link between the loss of the house and the separation. Like that, they won't blame the faulty parent, the parent that they think is at fault for them losing their house. So I think it's, sometimes it is a little difficult to keep it for that additional year, but when it's possible, I find it gives grace and time to breathe to the spouse that might be more fragile, and also permits the children to heal while still being in the house, and then be ready to move out, maybe let's say at the end of the next school year, if possible.
Wow.
Beautiful. That's a
For
nice
sharing
ending.
that. It was a bit heart-wrenching.
Thank you so
but
much.
it's
Thank you.
Thank
We're-
you.